Dear Lord, dear Lord in heaven, we're so thankful for your goodness and your mercy towards us. We thank you for all your blessings and all you give to us this Sabbath day. We ask and pray that you may be with us. Please grant us your Holy Spirit to understand spiritual things. We ask and pray that you may enlighten us and strengthen us, Lord, at this time. And please grant us understanding. We ask and pray all this in Jesus' name. Amen. Amen. Can you hear me fine, by the way? I'm using a new device, so I'm not sure if I'm coming across clear. Sorry?
Can hear you. Can hear you. Oh, I
Okay.
can.
Okay. So what I wanted to look at today is actually quite interesting because there's a continuation of a bit of a discussion on the Bible study forum this morning about it is the Equal Rights Amendment. So in this past week, there's I don't know if you call it a law. Yeah, basically the Equal Rights Amendment was blocked again, from being enshrined in the Constitution, when it went through Senate. And I just wanted to have a look at this Equal Rights Amendment, look at its history, look at why it's important and what actually was blocked in Congress. I think it was a few days ago, about 3 days ago, 4 days ago. Yeah, so wanted to have a look at the Equal Rights Amendment, its history, and then some interesting things about what people say to oppose it, and so on and so forth. So I'm hoping this will be more interactive. So your input is really encouraged. Any questions, any comments, feel free to feel free to jump in. I'm just going to share my screen so we can read an article that I think gives a really good overview of the Equal Rights Amendment. That's why I'm changing my screen, because let me say changing my device because my screen normally gives a bit of an issue on my tablet. Can you see my screen? Yes, no?
Yeah. Yes.
Yeah. Yes.
Okay, so this is an article that's published in January 2020, and it talks about a bit about a about a state that's ratified the Equal Rights Amendment, and then it'll go into a bit of the history. So on January 15th, Virginia became the latest state to ratify the Equal Rights Amendment, or the ERA, which is a proposed amendment to the Constitution that guarantees equal rights for women. So currently in the Constitution of the United States, equal rights for women is not guaranteed. So as we'll see, there's the 14th Amendment, which kind of removed discrimination of any kind, but when it was written, it was intended to be written for slaves at the time, and these were male slaves. And so what happens is, as people refer to the 14th Amendment, the interpretation of that 14th Amendment, it can sometimes be used to uphold women's equal rights for women, but other times, depending on who's interpreting the Constitution at the time, it can be, an argument could be made that actually this wasn't upholding equal rights for women. So the Equal Rights Amendment is to kind of enshrine that explicitly, that women have equal rights under the United States Constitution. So this measure, the ERA, It emerged as a top legislative priority after Democrats took control of both houses of the Virginia Assembly for the first time in 2 decades, leading to the election of the first female Speaker of the state's House of Delegates. It received bipartisan support both chambers. This historic vote follows recent ratifications by Nevada in 2017 and Illinois in 2018 after 4 decades of inactivity. So we'll see what that 4 decades of inactivity is and why it's important that Nevada, Illinois, and Virginia ratified this Equal Rights Amendment. So the Constitution provides that amendments take effect when 3/4 of the states ratify them, putting the current threshold at 38 states. So this means that amendments can take effect when 3/4 of the states. So there's 51 states. Is it 52? Sorry, could someone correct me there? Whoever is certain on how many states there are. So basically, 3/4 of them, if 3/4 of them ratify an amendment, then this amendment takes effect in the Constitution or as part of the Constitution. So this is why it's important that Virginia was the 38th state to ratify this ERA since Congress proposed it in 1972, which technically pushes the ERA across that threshold. But we'll see that it's technicality, and there's some issues to it actually being ratified. And that's something to do like a deadline that states were given to ratify the ERA. So there are still hurdles in the ERA's path. The ratification deadlines that Congress set after it approved the amendment have lapsed, and 5 states have acted to rescind their approval. These raise important questions, and now it is up to Congress, the courts, and the American people to resolve them. So what is the Equal Rights Amendment? So the Equal Rights Amendment was first drafted in 1923 by 2 leaders of the women's suffrage movement. These were Alice Paul and Crystal Eastman. And so I think one of the moves that was recently made in Congress was, it's actually a 100-year anniversary since this was first drafted. So this Equal Rights Amendment has actually been drafted in different places, different stages for a whole 100 years, which is, I don't know, a bit mind-boggling, because the other amendments to do with, for example, race, they were passed a lot quicker, and they got came enshrined as part of the amendments pretty quickly. So the fact that this has been around for 100 years shows you how much of a problem there is. Does anybody have any questions so far, by the way? Okay, I'll take that as no. Okay, so for women's rights advocates, the ERA was the next logical step following the successful campaign to win access to the ballot through the adoption of the 19th Amendment. So what this means is that I think in 1920, women, the women's suffrage managed to get rights for women to vote. So that's what it's talking about here. So there's a successful campaign to win access to the ballot, which is to vote. And once that that right to vote was given, the next logical step was enshrining the principle of gender equality in the Founding Charter. And that would not only give the right to vote, but then open the door to more rights and more protections, more provisions for women under the Constitution. So while the text of the amendment has changed over the years, the gist of it has remained the same. The version approved by Congress in 1972 and sent to the states reads, "Equality of rights under the law shall not be denied or abridged by the United States by any state on account of sex. The Congress shall have the power to enforce by appropriate legislation the provision of this article." So you can see here it's being very explicit on the account of sex, and this is important to understand, because remember when you look at the the Bill of Rights, it starts by saying all men are created equal. But then because that all men are created equal applied to only white men at the time, you needed another amendment to kind of specify, actually people from different countries or different origins, people were previously enslaved. You had to be explicit to make sure that, there's no ambiguity in interpreting the Constitution, in interpreting the law, in administering the laws, when there's a dispute, or when you're making new laws, to make sure that it abides by these principles in the amendment. So does that make sense? Why this has to be explicitly said? It's not just oh, we have the 14th Amendment that talks about equality for, you can't discriminate people, but then you need something to actually explicitly say that you can't discriminate based on sex, in the same way that you need an amendment to explicitly say you can't discriminate based on race, when the original Constitution could still be read to say that. Okay. So beginning in 1923, lawmakers introduced the ERA in every session of Congress. Is that someone unmuting the mic to speak?
Yeah, I wanted to ask a question, and it's just gone from my mind, actually. When you didn't answer straight away, I thought because my mic wasn't unmuted, but it was. But anyway, no, if I think about it, I'll come back to you.
Okay, sure. Yeah, please do unmute your mic, because I can't see there if there's any hands raised. While I'm sharing my screen. Okay, so beginning in 1923, lawmakers introduced the ERA in every session of Congress. So literally every session of Congress, it was introduced since 1923, but it didn't make much progress until the 1970s. And obviously it didn't help that for most of the 20th century, Congress was comprised almost entirely of men. So in the nearly 5 decades span between 1922 until 1970, which is about the time where the ERA was taken more seriously in Congress, only 10 women served in the Senate, with no more than 2 serving at the same time. And this picture is only slightly better in the House. So you can imagine that, you're trying to propose this bill for equal rights for women, but the people in power who have the power to adopt that and change it are all men. So that is, it's kind of conflict of interest, and maybe one of the reasons why it took such a long time to actually be considered properly. But
okay, Tom, I remembered, sorry.
Okay.
So, when you read the Constitution and it said did it say all men are created equal? Did people actually believe that it was just men? Or was it generic to say men and women?
So this is the thing. When it says all men, it's kind of like it should really be humanity, like every single human, when they use that. But then at the time of writing, the framers actually really meant white men. So it wasn't women included, because women still didn't have the same rights as men. And it wasn't people of different ethnicities, because they still had slaves. Slavery was still legal, and that principle, or when that was introduced, didn't do away with slavery. It didn't do away with women not having rights. So although it says all men are created equal, the intent of it wasn't. It was basically white men. And
So people knew that. So did everybody know that?
I suppose I don't know what you mean by everybody knew that, because
I
it's
mean,
more
when
like a
people read the
mindset
Constitution,
of
did
society.
everybody believe that it was just white men or just men in general? Or people in general, but it was only geared towards white men.
Yeah, so this is what I'm saying. I think it's difficult for me to say, like, did everybody know that it was just for white men explicitly, because it's more of a condition of society's minds. So at that time, it's kind of like a given, like a subconscious, like, oh, literally just white men can own this, and that you feel like that doesn't really apply to me, because I'm not part of them. If you're a woman, you looked at that and you kind of knew that you were excluded because you weren't seen as a human in the same way. So was it explicitly said it's white men? No, it wasn't explicit, but it was implicit by how society was at the time.
Could I give
It
a
was
response?
implicitly applied.
Sorry?
Could I give a response to that question?
Sure.
Part of the argument that is going on in the United States now, particularly at the Supreme Court, and we in this movement have discussed this over and over again, is the difference between what some people term a phrase that's used is a living constitution and originalism. And the difference is everybody reads the words of the Constitution, which I think is what you're asking, Cedri. What do the words say? So there's what the words say. Everybody knows what they all say, and everybody's in agreement with what those words say. But the difference between perspectives is that originalism doesn't just say what do the words say. What they want to do beyond that is try to understand what the authors meant when they said that. And so, as Tom has alluded, you have to look at how society views things, what the cultural norms are. So it's not just the words, but it's what people think who actually wrote those words. And that becomes important when we start trying to understand what, say, the Constitution or an amendment means. And the other side of this argument is in the 21st century today, when we read those archaic documents with that archaic language, in fact, we struggled with that this morning in the hymns, if you all participated in it and listened, that all the hymns use archaic terminology, and we could simply say, we know God doesn't have a gender, so when the hymn says him or he, we know what that means. And so people say, well, you don't have to change the words, and other people say you do change the words. But this idea of a living document or a living constitution says, we know what the words say, all men, but in the 21st century, that word men should be changed to mankind or humanity, which is an all-encompassing term. And the originalists say you can't do that. So that's the problem about when you see these documents, what they mean and what people originally thought they mean and what people today think they mean. And there's all these variations. So even though your question sounds straightforward and can we just give a yes or no answer? I don't think it's that straightforward to do that, because it depends on a person's perspective. The words say men. And if you ask today, what does that mean? That would mean to us humans. But if you ask other people today, they would say, we know what they meant when they said men. They meant a certain group in society, because they certainly knew that all black people, all slaves were not created equal to white people. Everybody knew that back then. That's their thinking. So when they say all men, they say it with a perspective, but they use kind language. And if you were to pin them down and say, what do you mean all men? They would probably say all human beings, all humanity. But the reality is they never thought that way. And that's where the problem arises. People don't think that way, even though the words can be used to mean many different things to many different people. So even though your question seems straightforward, it's not that straightforward to answer it, I think. I'm done.
Thank you, Tom, and thank you, Elder Paminda.
Can I add to that? I was thinking that's the same. It's the same as when we say, do people realize that we live in a patriarchal society, or do we function in that kind of way? And I think it's just ingrained culturally that that's the way it is. It's not even a realization, but people are at different levels of realization as to what that looks like and what it means. But I wanted to make another point. You're just reading about the women's rights, I suppose, with the Equal Rights Act, and you've just come on to the 1970s, and I think it's significant. We know from the movement that this test of equality is racism and then sexism, and we make the point that unless racism is dealt with, we haven't got a chance with sexism, in a sense, with that progression. And we see that even though Black men got the vote in the 1870s, that Black women didn't, and that they didn't have equal rights until the 1960s. And I'm sure, and I think this is significant to understand with this whole Equal Rights Act, that the women were never going to get equal rights until Black people had it. And it was 1964, obviously, with Martin Luther King, that the whole Black rights issue was agitated, Civil Rights Act was agitated. And I think on the back of that, that's why we see the resurgence of the Equal Rights Act in the 1970s, or at least it having some kind of impact in the 1970s, because it's on the back of the Civil Rights Act.
Yeah, that's completely right. And just going back to what Elder Paminda was saying, I think this is why the Equal Rights Act, the Equal Rights Amendment, is important to ratify, because it removes that ambiguity of, as he was mentioning, if you're trying to interpret the Constitution, is it by what society thinks now, or is it what was originally intended? And you get into this thing, it becomes about how you read, or how you can interpret it to say what you wanted to say, but having something explicit removes that ambiguity. And so the same problem that you're having, CG, you're saying, okay, does this include, is this white men, or is it Black men, is it women? These amendments are designed to do that you put them in, and like there's no more kind of, does the Constitution actually protect Black people? Does a Constitution actually protect women? That's why it's important, because it removes that interpretation, because interpretation can change over time or from individual to individual. So that's why it's an important piece of legislature.
Could I just make a comment?
Yeah.
Earlier, at the beginning of the study, you mentioned the 14th Amendment, and you briefly spoke about the context of that, which was all correct. And we know that the 13th Amendment, which is the abolition of slavery, is closely followed by the 14th Amendment. And people use the 14th Amendment has got 4 separate sections to it. And normally when people deal with the 14th Amendment, and we've discussed this in the movement quite a lot, is about due process under the law. And this is why people have argued that you don't need a new amendment, because under the law, it states, simply put, one of the sections, that everybody is equal under the law. And when you have that position, people say, well, that covers everybody. And the problem with the 14th Amendment, as you've highlighted, is that, first of all, it comes in various sections. I just want to read a small segment from section 2, because it gives you an idea of people's thinking. And the other thing that's important about amendments that we need to understand is the way amendments are written is that they take the ambiguity that's inbuilt in the Constitution away. The whole purpose of them is to clarify things and hone things down, so it's written in much plainer language than the amendment is, than the Constitution, which is much more flowery. And that's why when you read this latest amendment, it's almost like a sentence. It's really succinct and to the point. But I just want to read a small segment from section 2 of the Constitution of the amendment of the 14th Amendment, because it helps you to understand what their thinking is at that time. This is just after the Civil War. It says, legislature thereof is denied to any of the male, which is men, inhabitants of such state being 21 years of age and citizens of the United States. So basically the purpose of that, of section 2, is saying what age you can basically become a member of government. But it says specifically only male. And then just like further down in that, and the last part of that section of the amendment, it says, in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in any such state. So it talks explicitly, because that's what amendments do, they clarify details, and it's all about men in the 14th Amendment. And I think people are lax in their explanation of what these amendments are. People just say the 14th Amendment is due process, which means we're all equal under the law. And so that may be correct to a degree in one of the sections, but when you see the whole thought process there, this is all about, as you've rightly said, the issue of slavery, which is all about black men. And you have to wait a number of amendments before you're even going to get voting rights for women. So I just wanted to add that point there, that the reason why people say the 14th Amendment is not enough, because inbuilt in all of this is this maleness. I'm done.
Can I just ask a question? Is it the amendments that make it defunct type of thing or not?
Can't ask me a question, but they won't hear you.
I'm just wondering if what Elder Perminder's saying, that the amendments of the 14th Amendment, section 2 that Elder Perminder is talking about, is that the problem with the 14th Amendment? If those amendments weren't there, would it be a different scenario? That question goes to Elder Perminder.
No, I don't think it's. No, I don't. No, simple answer.
It would be just as bad. 14th Amendment, how?
14th Amendment isn't bad. I don't believe it is bad.
What you're saying it is because it's talking about the men, and is that to do with it all, the context of it being white men? What was the point?
My point was that when Tom was bringing the reason,
slavery.
when he was bringing the reason that we need a new amendment, even though he hasn't said it that strongly, people go to the 14th Amendment, which is why he took us there, I think. And even though he didn't go into the details of the 14th Amendment, it's clear if you read it, which I think he understood, that the 14th Amendment doesn't do the job that's required in the 21st century. That's what the problem with it, and it's not sufficient. And when people argue that it is sufficient, you can begin to see, I think, relatively easily that it isn't. I think that's why he says, I don't put words into Tom's mouth, but I think that's why he said 14th Amendment isn't good enough. It doesn't do the job today for us.
And you added to that with the section 2.
And I just wanted to point out that if you read it, you can see the point that Tom's making, even though he didn't read it.
Okay.
I noticed
Yeah,
that this has not been recorded.
No, I think it's
No,
being
it is.
recorded.
It is.
Yeah.
It is.
So
Yeah.
Okay, thank you.
Yeah, just to answer that question and give my my view of it, I think it's maybe not the right way to view is an amendment good or bad. It's important to see the progression and see that it sufficed for something, but it didn't suffice for everything. So even look at the Bill of Rights and you know, these phrases of all men are created equal, although it's talk about they intended it to be white men. Actually, at the time, it was quite progressive. It was the right thing, because before you had these monarchies and you had, you know, the individuals didn't have rights. You know, they didn't have rights of conscience. You had to, you know, obey what the monarchy said, how to worship and things like that. But then it was not an end point. You couldn't just stop and put down and say, okay, well, we don't need any more changes. And then changes would come later in terms of, you know, including the 14th Amendment, changes to allow, you know, Black people freedom and rights and due process and things like that. And that was right, but it wasn't all encompassing. And I think that maybe that's how I think about it. And that's maybe more of the problem is not that the 14th Amendment is not the problem. The problem is that it's not enough to cover, you know, to cover all people. And so you need to recognize that and progress and have it cover more, you know, as time goes. So it's less of a good or bad and more like, okay, that's a step, but we need another step and another step and another step and another step. So I think that's how I view it. So when Elder Paminda is talking about how it only intended to be for Black people at that time in the context, it was good. These legislations should have come earlier anyway. So we're not saying that it's good that it took time for it to come, but then it was good in what it did. It just needed an addition for sex, for gender, as we're talking here. So I think it's just saying that it's not sufficient for everybody. That's how I understand it.
Can I just say something? With the Equality Act, I would think that that's more to do with sexual orientation if we bring it to our day, and gender, but we also had the 28th Amendment, which was all about women's equality, which they didn't pass either. So I think this has got a bit of a slant on it, the ERA, because it's going to bring in freedoms for sexual orientation, I think, for gender, where the 28th Amendment wouldn't, or the 14th Amendment. None of them are
Okay.
anyway, ever. The 28th or the ERA, they're not going to get passed.
I think it connects to the fact that it's a living document, doesn't it? What you're saying is it didn't go far enough. The 14th Amendment, it was a good step at the time and it was valid and needed. But it's like anything, it needs to continue to grow and make those changes. And if it stops growing, it's not fit for, well, it doesn't do the job it's intended to.
Yeah, and maybe that's where the living part comes, is, you know, something's dead, it doesn't really change, whereas if it's living, it's kind of changing and being added to, and kind of growing and maturing, and maybe the amendments are what are making it that living document, because it's addressing the issues highlighted at each time. Okay, so yeah, so we talked about how this in 1923 that this ERA was introduced, and it kind of didn't go anywhere until the 1970s. So, and part of that was that there's a lot of basically Congress was comprised and basically entirely of men. So in 1970, a new class of women lawmakers, including Representatives Martha Griffiths and Shirley Chisholm, pressed to make the ERA a top legislative priority. They had to overcome the resistance of Republican Representative Emanuel Sella, that's how you say his name, the powerful chairman of the House Judiciary Committee, who had refused to hold a hearing on the ERA for over 30 years. So this person, Emanuel Sella, the chairman of the House Judiciary Committee, and had refused to hold a hearing on the ERA for over 30 years. So that goes back to one of the reasons why the ERA didn't get very far, was this resistance by this man. Faced with increased pressure, though, Sella finally relented. In March 1972, the amendment passed both chambers of Congress, with bipartisan support far exceeding the 2/3 majorities required by the Constitution. So Congress promptly sent the proposed amendment to the states for ratification with a 7-year deadline. So what this means is that in 1972, the amendment has passed both chambers, and they're going to send it to the states to ratify. So it's sent it to all 52 states. And remember, before we talked about how 3/4 of the states needed to ratify, and I think the threshold was 38 at the time. So they needed basically 38 states to ratify for it to be enshrined in the Constitution. Yeah, So within 1 year, 30 of the necessary 38 states acted to ratify the ERA. But then momentum slowed as conservative activists allied with the emerging religious right. And they launched a campaign to stop the amendment in its tracks. So there's a lady called Phyllis Schlafly, that's how you say her name, Schlafly, a conservative lawyer and activist from Illinois who led the Stop ERA campaign and argued that the measure would lead to gender-neutral bathrooms, same-sex marriage, and women in military combat, amongst other things. I want to read some things by Phyllis Schlafly in a moment. But so yeah, so you have 30 of these 38 states, necessary 38 states already within a year, they ratify this ERA. But then you have now this opposition to the ERA coming up. And it's interesting that one of the main opponents was this lady, Phyllis Schlafly, who was a conservative lawyer. And so the opposition, and we'll see some of the arguments that they made. So some of it was like gender neutral bathrooms, same-sex marriage, and women in military combat. So they'd use all these like straw man things to try and combat this ERA, and it was remarkably successful. So there's still 7 years. So there's still 6 years for 8 more states to ratify. Because the original deadline was 1977. So this opposition campaign was remarkably successful, and support for the ERA eroded, particularly among Republicans. Though the GOP was actually the first party to endorse the ERA back in 1940, which is interesting, those same lawmakers called the amendment, leading to a stalemate in the states. By 1977, which is the deadline, the original deadline, only 35 states had ratified the ERA. So 30 had ratified it within the first year, and it took another 6 years for 5 more to add their names to this to ratifying this ERA. So the deadline has come, and they haven't met the quotient. So Congress voted to extend the ratification deadline by additional 3 years. So from sorry, no, 1977 wasn't the original deadline. The original deadline was 1979, because that's 7 years from 1972. So in 1977, they see, okay, it's taking us some time, so let's extend the deadline. So the deadline was 1979, they extended it to 1982. So even though they extended this deadline by additional 3 years, no new state signed on. Complicating matters further, lawmakers in 5 states, Nebraska, Tennessee, Idaho, Kentucky, and South Dakota, voted to rescind the early support. In 1982, which is now where the expiration of this extended deadline, most activists and lawmakers had accepted the ERA's defeat. So that's what happened. You had this ERA, it was taken to Congress, they passed it, they said, okay, it needs to go to the states for ratification, and they needed 3/4, which is 38 states, to ratify the ERA. And within the first year, it's kind of like it sweeps very quickly. 30 states already put the already ratify it, but then you have this opposition to the ERA coming, and this opposition is actually really strong. Or in terms of the effect was really let me say it was effective in its opposition. And one of the spearheads was Phyllis Schlafly.
Tom,
yeah,
I just want to make a minor point on that second paragraph on the screen, that where the sentence points out that the GOP was the first party to endorse the ERA back in 1940. That can lead one to believe that it's the GOP/Republican Party in its current form. But as we're aware, the Republicans and Democrats have shifted in terms of where they stand on issues over the years. And I'm just bringing this because I think it's around that time, like in the 1960s, where the shift takes place. So the GOP in the 1940s might not be the Republicans as we see them existing today. Does that make sense?
Yeah, it makes sense. Yeah, completely. Completely agree. Okay. So Phyllis Schlafly, one of the ways that she combated this was through an article / speech that she made in, I think it was in 1972, and it's called "What's Wrong with Equal Rights for Women." So that's Phyllis Schlafly. I think she died in 2016. And so this is kind of like his speech that she made to kind of combat this this ERA, this Equal Rights Amendment. And I wanted to read it because it's quite interesting, and then read some of the opponents of it to this day, and some of the opposition that they still have. Before I read that, so just going back to this. So we have we had 35 states by 1977 had ratified this, and that means it was three states short of the majority of the quotient needed. And so that was in 1977, and then nothing happened for a long time until Virginia, Virginia, Nevada, and Illinois have since ratified it. And so that means that the current threshold is at 38 states. So the threshold has technically been met. But the problem is that, remember, we had this deadline that they had to do it by 1982. And so although the quotient has been reached, it's kind of been reached kind of too late after the deadline. So I think part of what was going on in Congress this week was to kind of say, like, okay, I know the deadline's passed, but it doesn't really matter. Let's ratify this Equal Rights Amendment because we've met the quotient, the 38 states. And so the opposition is like, no, the deadline has passed. Or some people, like I think Trump's party is saying that the ratification has to start all over again. So like everyone has to, like, almost unratify and start the process all over again in order for it to be enshrined in the Constitution. So that was what was going on this week was, and please somebody correct me if I'm wrong, but yeah, it was to say that the deadline has passed, but we have the 38 quotient. Let's just ratify it. Like almost like that deadline is a bit arbitrary. We don't need that deadline. But obviously that failed in Congress. So that was what was being discussed or being debated.
Could I ask I don't know if it's you or anybody, I guess, maybe because you've looked at this, maybe you'd be better placed to answer it. The states that didn't ratify, I'm going to say within the time limit, you said that 30 states, they needed 38, 30 did it basically immediately, and there were 8 that were lagging, and then it got to a stage where there was a few that were missing. Do you know why those states didn't ratify, I'm going to say back in the day? Is it because they actually attempted to ratify and they didn't get the votes, or they just said, we're not going to do a vote? What is the reason that they didn't ratify it? I'm assuming that they whatever the process for doing that is, they don't get the votes and it doesn't get passed in those particular states. Is that the reason?
It's a good question. I'm not entirely sure. I'm assuming that if Congress has said that this needs to go to the states, that they would at least have had a vote on it. I'm not sure if the states had the power to be like, we're not voting on it.
From what I recall when I looked into it, is that some states just didn't hold a vote on it at all, and some others voted against it or failed to secure enough votes for that ratification. And one of the factors that played a role in that failure was that from those conservative groups and individuals who saw it as a threat on general structures, etc. So there were some that just didn't hold a vote at all, and there were some that voted against it.
So the ones that vote against it, that's clear. The ones that didn't vote, is that because they don't want to vote, because they're opposed to it?
I can't speak for all reasons, but for one of the reasons was it was just a clear, like, we're not going to vote on it because of these sexist reasons, etc.
The reason why I asked that question is, Tom, earlier in the study, you said that there were these states now that have just passed it, and then obviously the Democrats are saying, well, we've got the number, it's all good. But I think you alluded to the fact, and I think I may have heard it before, that there are other states who say we've changed our mind now. And if that's correct, and maybe you can just clarify if that's correct, do you think that's, or do we think that's a reasonable argument? They say we've changed our mind. We said yes before, but now we change our mind and now we're saying no, because the Democrats are saying, I think their argument would be, it's too late, you can't change your mind. Once you vote, that's it. It's set in concrete now and you can't change your mind. And I don't know if we think that's a reasonably fair argument for the Democrats to make, or if it's, I'm going to assume they're Republicans, or if it's fair for Republicans say, we've changed our minds and we want to relook at this. The states, I mean, that originally said yes. So like, maybe Florida would have said yes before, and now they're saying, actually, we want to reconsider because it's going to be a no. Is that, because I think you said that, is that correct, that some states are saying no? I thought you may have said 5, but I might have imagined that. And if so, do you think that's reasonable for them to say we want to change our mind? And the reason why I'm asking that is because that's essentially what these states, these new ones that have just come on board, are saying. They're saying, we said no before, or we didn't vote before, or whatever, and now we're saying we're going to do it. It's almost like they're saying that we changed our minds.
And it's kind of like the Democrats arguing against those states pulling out is stabbing themselves in the back for other matters, because Republicans can say our states voted for something way back when, and so you wanting to come and change legislation now to be progressive is not fair, or it's not right. So I'm saying that whatever argument Democrats are making can be used against them for doing the same thing.
I'm not I suppose I'm not entirely sure what this rescinding the early support looks like, or what it means, when you ratify this bill. I don't know if it's something like a contract where it's easy to say I don't want to sign a contract, and it's easier to say one moment I don't want to sign a contract, and then 2 days later, okay, I want to sign it. I can sign it now. I don't know if it's a lot easier. It's a lot easier to do that than to say, okay, I've signed a contract, and then 2 days later, no, I want to unsign it. I don't know if it's something like that where the process of, giving support is a lot more streamlined than removing it in the sense, in the same way that a contract would be. Yeah, so I suppose I don't know the details of that, but it sounds that might be a play. Yeah, I'm not sure exactly when they rescinded they voted to rescind their support and what that looks like or what happened. It's probably something worth looking into.
On that argument of rescinding votes, I know it's come up as a matter of controversy between the two parties, because they argue whether it's legal to do that or not based on the Constitution, whether it provides, the framework for revoking a previously ratified amendment. And they argue that once the state has ratified amendment, its decision is final. But then the counter arguments that are brought is that they are valid and should be recognized because the explicit prohibition in the Constitution isn't there. So it's the exact same question that we face with other things of how do you interpret the Constitution?
So when you say explicit prohibition, prohibition of what?
Of you being allowed to rescind your ratification. So the counter argument is that you should be allowed to do it because the Constitution doesn't explicitly prohibit states from rescinding their ratification.
Do they have to, do you know if they have to enshrine it in their own state constitution in order to ratify it?
I don't know about that part, but the vote that they have is whether to do it at a federal level. I don't know if that then implies that it falls into their state level constitution. Well, if it passes at a federal level, then it's binding at a state level. Anyway.
Yeah, I'm just wondering if in order to ratify, they had to kind of enshrine it in their own constitution, and then that would make it very difficult to change as well. Because I suppose the way that the state constitutions work is quite similar to the federal constitution in terms of being able to.
I don't know. I don't have an answer.
The honest question, I don't really know the answer. I threw in all my thoughts, but I don't know. It might be invalid. Are you done with that point of the Paminda? Can we move on?
I guess I was asking people's opinions and
Okay.
if we think it's fair or not for states to basically change their mind because these new states, I presume that they never ratified it originally, and the reason they didn't ratify it, I think Curtis has said at least one of them, I'm assuming it has to be one of them, didn't take the vote because they said this is so bad an amendment, we're not even gonna give it a vote, let alone so they didn't even have an opportunity to pass off that. They just refused to give it the vote. And just because they refused to give it the vote because they didn't agree with it, and now they're saying actually 2 or 3 generations on, the grandchildren say we do actually agree with it now. It does. I know there's a legal argument perhaps about rescinding a contract is different to not signing it. I get that technicality in law, but I'm just thinking about our view of ethics and the morality, that if one group can change their mind, because that's what's happening, the grandchildren are saying our grandparents refused to vote because they didn't like it, but we like it, so we're going to vote and pass it. And the other side is saying our grandparents thought it was a good thing, but we don't think it's good at all, and we want to not agree with it.
I think the debate is less so about those states who didn't vote. If I'm not mistaken, they down the road ended up voting for it. So the argument it's more so about the states that did vote for it and rescinded their vote.
I understand that. But the latest 2 or 3, 4 states that have come on board now, the only reason they're doing that is because the grandchildren have a different perspective from the grandparents.
And are you asking, is it fair for the grandchildren to have that different perspective?
If it's fair for them for the Democrats to say, well, due process is due process, and if now this is the first time that it's going to go for a vote and it passes, that's all good. But the other states, the Republican ones, are saying, well, the issue, regardless of the legality of it, the issues are very similar, it seems to me. The reason that they're voting now positively is because their grandparents refused to vote. And I don't know if there's much difference between refusing to vote because it's such a bad amendment, we're not even going to consider it. What's the difference between that and saying, well, we'll vote and we'll win or lose either way, depending on what side you are? There doesn't seem to be much difference between that and the Republicans saying, actually, we voted for it 40, 50 years ago, and now we've changed our minds because we see things differently. It's one thing to snag people on a technicality, on a legal technicality, I understand that. But I'm wondering how we view it on the issue of fairness.
I understand what you're what your question is. I suppose it's fair for them to change their mind. Yeah, it's fair for them to change their mind, but yeah, it's fair for the grandchildren to change their mind. But I think also what we're talking about here is something that's legal, so we can't remove the legality of it. So we can be like, okay, fine, you can have a different opinion, but then changing your position or your ratification of that is actually a legal matter rather than your opinion, if that makes sense. So
does.
I think that's where the difficulty is.
It does, but as Curtis pointed out, the legality of that isn't even clear, as it is in none of these cases that are coming up. If it was a clear legal issue, the discussion wouldn't be happening, but it's not legally clear, and I think that's part of the issue, if I understood it correctly.
Funny enough, well, there's that really long article about originalism and its original intentions of wanting to stick to originalism. And one of the arguments that conservatives bring is that if you don't follow originalism, what you end up happening is every generation, just in inverted commas, making up their own things that suit them. And so where one generation passes something, the next generation comes and says, oh, well, we don't see it that way. And then they do what they're going to do. Then the following generation comes and says, actually, we don't see it that way. So it's a continual change of mind. And the argument made by originalists is that to avoid a continual change of mind on issues, let's just stick with what's originally there, where we have a framework where it's rigid. Obviously, we can argue against that, but that's the argument that they bring. And so us questioning, is it fair for Republicans, conservatives to say, actually, we change our mind? The same question can be asked, well, then is it fair for Democrats to say, well, actually, our grandparents were conservative and didn't want to vote on it, so we view it differently and want to vote for it? The question of fairness is leveled against both parties in doing so.
So are you saying that they don't believe in the living constitution then?
Are you asking me if I believe in the living constitution?
No, is that what you're saying overall? By what you're explaining, it sounds like they don't believe in the living constitution then.
Conservatives?
Yes.
Yeah, no, they don't. But they are hypocrites because why I say hypocrites is because they do so on matters that suit them and follow originalism in matters that suit them. I guess that hypocrisy can be leveled on both sides of not being like straightened to what you believe in.
I wanted to go back to this issue in the sense of that what the question I was having is linked to this whole, whether it's right that they change their minds, I suppose, is that what's the point of having a deadline if if past that deadline it means nothing what's happened up to that point, or no, that you can still carry forward? Because if the deadline means once we get to this deadline, whoever's voted, your votes are cast and they're set now, then we're starting with a blank page now, so anyone could do anything. They can vote what they want because we're starting afresh. But if those votes are now put on hold and it says we're going to hold everybody up to that point who's done what they've done, and maybe this is part of the discussion that the law isn't clear on. If that deadline means nothing, people can keep changing their mind, or votes can be added or not added beyond that point. What was the point of the deadline? And I don't know if that's part of the
and this is what like Trump and his kind of party are saying, that if we're going to do that, then let's let everyone start all over again, because you already have some people. So it is a complicated issue, and sometimes I don't know if we can say sometimes the best path or the most equal path sometimes isn't so fair for everybody. It's not, I don't know if it's not legally fair in terms of, I suppose if it was to be like, okay, we've got 38 now, so let's put it in, let's sign it into the constitution. I think that would not be exactly fair, because that's not, you know, imagine if it was if something bad, if it was something like, or that we consider bad, you know, there'd have been an uproar about it. So so yeah, so this is some of the complexities of legal life in the USA, and in the world is kind of this battle between is something is good always fair. I suppose we're coming from the point of view, oh yeah, it's good, let's pass it, but then I'm not sure it's entirely fair in the same way. So we've got just under half an hour left. I just want to go through.
Written something in the chat there, but shall I read it? Or you want to read it? Tom, do you want to read it?
Yeah, so Katie says the matter of the deadline in the first place is what's in contention, as well as whether there's a constitutional basis of having a deadline. Fair point.
Tom, I don't know if you're going to, I know there's not much time left, and I don't know if you're going to address it, but you don't have to answer this now. Do you think that the wording of this amendment is still fit for purpose? Because I know it's gone through various iterations, you said, but if it's a 50-year-old statement, do you think it's actually still fit for purpose in the context of what people are fighting for? You don't have to answer that now if you're going to address it through the remainder of the study.
Sorry.
Think is it
Is it-
RPG? Is that what you say? Her name? She said it wasn't. The Equality. Is it the Equality Act was more fit for purpose for what we're going through now?
So could you say that a bit louder?
Is it RBG? Is that what she said?
Yeah, RBG.
Yeah, I
we've
think
read it
she
yesterday.
didn't she say it was more she would have chosen the Equality Act rather than this ERA with regards to what was going on in her time before she died. And it was, you know, I don't know, was it to do with sexual orientation and stuff like that? When did she die? What year was it? 2020, wasn't it? Yeah, it would have been. I'm just saying that answering Elder Min's question, my opinion was it's probably not going to be beneficial for what's going on now, I think. That's my opinion.
Did you hear that? Tom?
Barely,
Oh, sorry.
but I just about heard it.
Okay. Doesn't matter, it's not important.
Just talking about RGB and okay, carry on. Just
Yeah, no, I did hear it. I did hear it, although it's quite faint. Yeah, I suppose it depends how we view these things, and like I said before, they're probably not. I don't think we'll ever get to an amendment where like, okay, that's got everything. That's it. We don't need another amendment. You know, so if this was passed at the time, we'd probably still needed another one further down the line, maybe for sexual orientation, and so on and so forth. And there might be, just like in all these other times, there might be things that they were blind to, you know. So when they were passing, when they're talking about race, you know, they're a bit blind on gender, and maybe at the time of gender, a bit blind on the sexual orientation. And who's to say that we right now don't have some of those blind spots that we don't see, that in, you know, 30 years we'll look back and be like, oh yeah, of course, like why did we not see that? So yeah, I think it's a continually iterative process. I don't think it'd ever stop, or there'd be one that's sufficient for everything. So definitely you need things added to the ERA to cover yeah, to cover more of the issues that we're more aware of in the society now compared to 50 years ago. Because maybe back then homosexuality was seen as a disease, or so, like, and it's, you know, people were made to feel like they were insane for homosexuality and things like that. So obviously at the time of writing, they didn't, in the same way the framers of the Constitution didn't encompass, they had a certain societal point of view while writing it. I think the same thing for the ERA.
So if I understand you correctly, you're saying that the wording, I don't know if you could restate the words as it's proposed. you're saying it's not fit for purpose anymore because it's 50 years out of date, if I understood you correctly.
I'm not saying it's not fit for purpose. I'm just saying it's not as all encompassing. In the same way, the 14th Amendment, I won't say it's not fit for purpose. It's just, it's not all encompassing.
But the difference is, and I think the reason why I'm asking is because you said this, I thought you just said it a minute ago, but the 14th Amendment, when it was written, ratified in quick order. And so in the context of their society, I'm going to suggest that it was fit for purpose. When you look back 50 years afterwards or 100 years afterwards, you say it's not fit for purpose today. But the MRA as it currently stands may have been okay 50 years ago when it was drafted. But today, should we be pushing or voting for something that we know isn't fit for purpose today because it's the best that we could do 50 years ago? Because as you pointed out, I think you took us to 1923, I think it was, which is like 100 years now, and it's maybe slightly modified, but this statement is 100 or 50 to 100 years old. That was my question. So I understand things progress, but where we are today, I thought you said that if you were going to write one, it should have something a bit more than just the way it's written currently, or maybe I've misunderstood that.
Yeah, I see what you're saying. I suppose I agree to some extent. Because even when the 14th Amendment was being written, there's still a lot of awareness of women's rights at that time. So I suppose you could go back and say that that amendment should have included women's rights at that time because they're quite closely linked. So I suppose what I'm saying is that I suppose first of all, the study wasn't to do with the content of it. Is the fact that we have this bill, this this amendment that's been in history and it still hasn't been passed 100 years later. And I suppose it'd be good to just kind of wave a magic wand and get everything in at the same time. So remember the time when blacks and women were fighting for equal rights. They came kind of, the amendments came like in for one group and then the other group and then the other. I don't think there's many amendments which covered many groups, which covered everybody. So in the same way, I'm saying I think you'd need amendments you need additions to the ERA to cover a wider base. So for example, it doesn't talk about sexual orientation or any of those things. I don't think really deals with issues like trans, kind of defining like transgender women included in this or not. So I think that there is more to be done on top of it, but I think it in and of itself, I think it would be a stepping stone at the very least.
Tom, correct me if I'm wrong, to both the questioner and you, Tom, but from what I understand, the question isn't whether when it was written it was fit for purpose. It's states voting for it today. Would it not be better for them just to create a new amendment that addresses the issues today instead of voting for something that we know doesn't today? We can look back and say it did then, but why not just create something today? Like there's no point putting that stepping stone today when we see things that are better, whereas then they couldn't see beyond where they were. Today we are living in a situation. So the proposition is just vote for a new amendment, not this ERA, how it stands.
Yeah, no, I understand that. I think why I answered the question the way I did is that if the simplicity of this ERA is still not being ratified, adding more to it, I don't know if that would make it. So I suppose that there's two answers. There's like an idealist answer, and then there's like a, what would be the best pragmatic course of action. I would think pass this one and then add to it. Because if you add to it, and I suppose I still wanted to read some of the opposition to the ERA, just overcoming those hurdles of that opposition. If you add, more current things, it might delay at least getting those provisions required for sex at the very least. So it's kind of like get the provisions for sex and then let's work on the other things while we're waiting, rather than waiting on both. I suppose that's.
If I could just make an observation, I don't want to put words into anybody's mouth or compartmentalize anybody. So anybody listening, please don't take this literally. But if I could just take Tom and Curtis, and I could give you labels, if you'd let me do that, that Tom is a compromiser, which is a true Democrat. We've identified the Democrats as the compromisers. And Curtis is suggesting a more idealistic perspective, a more purist one, like let's do things properly. And this argument that goes on, because we tend to use the word compromise as a dirty word, but the point that I think Tom is making is that, and I'm not trying to box any of you in, so if I don't mean to misrepresent you, either of you, but if we're not realistic, we won't get anything done. And it's better we're 80% of the way through this, the MRA as it currently stands, ERA, sorry. We're 80% there, so let's just finish that one off and see what we can do for another amendment, because if we add LGBTQ issues in it, we're not going to get that amendment passed for another generation. I think everybody knows that. Real politicians know that. Real Democrats know that. So I think their argument is, well, let's just get what we can get, even though we know it's not good enough. And I think we could argue, well, that's hypocrisy or that's really bad policy. We could make those purist arguments, but I think what Tom is I'm not saying he's proposing, but he's counting that argument to say, isn't it better to get an incremental step done than get nothing done? Because if we make this more stringent, it will never get passed for another who knows how long. And at least we're 80-90% of the way there almost. I mean, they only missed it with 9 votes. They could have passed this whole thing. They're really, really close to getting this sorted out. And I think it's important for us. The reason why I'm making that point is because not only on this issue, but on other issues, it's important for us to understand where our positions are individually and corporately on these issues. That are we willing to take a lower position, which we know is not right, but get that passed, or do we always just say we are the high ground or no ground? And I think sometimes we're not sure where we should be standing. I'm done.
Okay. Yeah, I think that's a fair characterization of what I was saying. I don't have anything to argue against that. All right, so we've got 12 minutes or so. Yeah, I just wanted to read through what Phyllis Schlafly says, and then also just have a look at what a more recent opposition say about this ERA. So there's this I don't know, publication or a speech, a newsletter. It's called "What's Wrong with Equal Rights for Women," and this is in 1972. So this is basically what she says. So this is her opposition to the ERA, and this is just to give us an idea of how she was thinking, how society was thinking about it, or maybe how society still thinks about it. So she says, of all the classes of people who ever lived, the American woman is the most privileged. We have the most rights and rewards and the fewest duties. Our unique status is the result of a fortunate combination of circumstances. Number one, We have the immense good fortune to live in a civilization which respects the family as the basic unit of society. This respect is part and parcel of our laws and our customs. It is based on the fact of life, which no legislation or agitation can erase, that women have babies and men don't. If you don't like this fundamental difference, you will have to take up your complaint with God, because he created us this way. The fact that women, not men, have babies is not the fault of selfish and domineering men, or of the establishment of or of any clique of conspirators who want to oppress women. It is simply the way God made us. Our Judeo-Christian civilization has developed the law and custom that, since women must bear the physical consequences of the sex act, men must be required to bear the other consequences and pay in other ways. These laws and customs decree that a man must carry his share by physical protection and financial support of his children and of the woman who bears his children, and also by a code of behavior which benefits and protects both the woman and the children. So she's basically saying that women in America are the most privileged because basically they have so much and they don't have to do much. And also, I suppose she's blaming God. She's saying like, it's God who made, it's basically God's fault that we're like this, and this is how we have to be, in terms of how God created us, and women have to bear the children and bear the physical consequences of that, and men have to do it in a different way. So that's what she's saying. She's saying that the way women bear, how women bear, the difficulties, and how men bear difficulties are different. So she also talks about the institution of the family being a bedrock, and it's important to realize how important that was and still is, and it's probably one of the biggest issues in the way of women's rights. We want to talk about the disparities in the gender pay gap. A lot of it nowadays is actually driven by the difference in the home, how the home is run, who takes time off, who looks after the children, and so on and so forth. So it's still something that is in play even to this day. So the greatest achievement of women's rights. This is accomplished by the institution of the family. A respect for the family as the basic unit of society, which is ingrained in the laws and customs of our Judeo-Christian civilization, is the greatest single achievement in the entire history of women's rights. It assures a woman the most precious and important right of all, the right to keep her own baby and to be supported and protected in the enjoyment of watching her baby grow up and develop. And this is also alluding to abortion. So she talks about the institution of the family, that how it's actually so advantageous for women, and how it's kind of like what women should, to see it like it's like such a blessing, and that just having children and watching them grow up is the biggest blessing that a woman can have. She also goes on to talk about the financial benefits of chivalry and how American women are privileged because, men are supposed to honor and respect women and provide for them and protect protect for them. I think I might link this article just for time. I'll link this article in the UK Fellowship Forum, so you can read it. But it's interesting to go through this article and see what she was thinking, or what she was saying about how, in her opposition to the ERA, how women are like in this privileged place, and so if we look at kind of like a modern, I found this forum, this basically it's a 10 reasons to oppose the Equal Rights Amendment, which kind of encapsulates the salient issues or the salient points going through the oppositions of the ERA. And so I suppose I found this a bit easier to read and understand if you just like 10 reasons to oppose the Equal Rights Amendment. So one of them is that the vague, poorly written language of the ERA does not allow any distinction to be made between men and women, even when it makes sense to do so based on the biological differences. As a result, the ERA will harm women and their unborn children by overturning laws and programs that benefit them. So they're saying that actually, although the ERA looks like it's giving rights to women, it'll actually harm them and their unborn children, because the way things are right now, women are protected and the children are protected. So it's kind of like making it seem reverse, like the other way around. And when you see how they're thinking, you can start to understand why a lot of why people would be opposed to it, because it looks like, oh, you're taking protections away from women. It's not that we're trying to deny women from having rights. We're trying to make sure that the protections aren't taken away from women. So the ERA would be used to overturn all restrictions on abortion, including the partial birth abortion ban, third trimester abortion ban, and parental notice of minors seeking an abortion. The ERA would be used to mandate taxpayer funding of elective medical abortions. So abortion plays a big part, and this then says the ERA would harm the unborn children because women would be able to have abortion. There'd be no restrictions on abortion, and not only that, the taxpayer would pay for these medical abortions. So number 4 is that the ERA would overturn laws and practices that benefit women because they would be viewed as showing preferential treatment to women. The laws and practices that would be overturned include workplace laws that provide special accommodations for pregnant women, state labor laws and guidelines which benefit women who do heavy manual work, government programs that support women as mothers, such as the Women, Infants, and Children Nutritional Program, social security benefits for stay-at-home mothers based on their spouse's income. So Justice Ginsburg, Ruth Bader Ginsburg, claims that the current gender-neutral benefit language is still a violation of the equality principle because it encourages women to stay out of the workforce, and as such, she would overturn the benefit. The exception of women from the military draft and frontline combat. Currently, women who feel they're physically able can choose to enlist in the military. The ERA, however, would require that all women be drafted in and placed on frontline combat in equal ratios to men. So what they're saying is that at the moment, like, women can enlist in the military, but they're not, if there's a draft of the military, for example, if there's like a war going on, women would have to come at equal proportions and they'd have to go to the front line, kind of like what's happening in Ukraine. These women and children were allowed to flee Ukraine, but the men weren't allowed to. They had to stay. They're kind of drafted, or what happened in Russia, these young men were drafted. But what they're saying is that, oh, if we pass this ERA, it means that the women would have to stay behind as well and fight just as much as the men and die just as much as the men, or whatever. So you can see it's kind of this, oh, women are protected under this because they don't have to do that. They can escape and flee, and it's only the men who have to fight. And so on and so forth. Another one is that the ERA would impact the privacy and safety of women and girls by removing gender designations for bathrooms, locker rooms, jails, and hospital rooms. The ERA will not give any more rights than they currently have. So we discussed this a bit. It says that women already have claim to equal rights through the 14th Amendment, as well as numerous other laws in virtual areas of American life. Employment, including equal pay, education, credit eligibility, housing, public accommodations, etc. And the US Supreme Court has already applied the 14th Amendment to women's issues. So goes back to what we're saying about the 14th Amendment. It has been used to uphold, to support women's issues, but it's not a guarantee. It's kind of like someone interpreted like that at the time, but you can always interpret it differently. And then they talk about the ERA wouldn't erase the gender wage gap, because women are already guaranteed equal pay. And the ERA would also transfer large amounts of legislative power from the states to Congress. creating a greater imbalance of power and placing sensitive issues under the less responsive federal government. And then again, I know this, it seems like another one, but it's the same as before, talking about restrictions on abortion. And finally, they talk about the time limit, the time limit for the constitutional amendment. So I think Curtis mentioned that the time limit for the constitutional amendments was that constitutional anyway, but isn't that like a given thing that ratification of constitutional amendments have to take 7 years regardless of what they are? That's a question for Curtis. But anyway, so I found this quite helpful to see how the opposers of the ERA are framing this, and you almost seem like, and you can understand maybe why even women would get involved in this, because you think to yourself about why would a woman block this ERA? But it starts, you start to have these things, use extreme things like, oh, it means you can be drafted and you can go to war, and so someone might think, oh, I don't want to go to war, let me protect myself from going to war, or whatever it may be. And so it's being framed as not rights for women, but taking away protections from women. And that's why there's such a strong opposition to the ERA. Yeah, I think I'll stop there. I'll share some of the articles that we've read in the UK Fellowship Forum. And so does anybody have any comments on kind of these 10 reasons to oppose the Equal Rights Amendment, or what some of the things that Phyllis Schlafly was saying?
Just a question about clarification. Is that, are any of those harm to women think that are they actually true? I mean, that last one, not last one. The fact that it would do away with dependent wives' medical bills, alimony, child support. I mean, would it actively go against? Would it enforce on that level?
I'm not entirely sure. I think some of these might be just scaremongering.
Yeah, that's what I thought. So I just wanted to clarify that. Yeah.
But then I can't say that with certainty. I haven't actually looked into the far reaches of what would happen and what the basis of these medical bills and things like that. There's a law. Sorry?
Sorry, no, it's all right, Karen.
So here, for example, it says laws and presumptions that support women in the areas of alimony, child support, and requirements of husbands to pay for their dependent wives. And then the ERA will also wipe out state laws that exempt a wife from having to pay her husband's debts, even if he deserts her with children to support. I'm not sure. I suppose it sounds a bit credible. I'm not entirely sure how credible it is. I think some of it does sound like scaremongering to me. I'm sure some of these things are stretched and that won't actually happen. But to me, it sounds sometimes a bit like, it's almost like, let's not give people freedom in case they hurt somebody, in case they kill somebody, or in case they steal something. Just because there could be a negative consequence also doesn't necessarily mean that you should deny the freedom either. Yeah.
I know you said at the beginning as well that she used straw man techniques. You said that phrase about her saying that this will end up with gender neutral bathrooms, gay marriage. There's a couple of things there which we have, all of which we have now. So I don't know whether that was straw man because you're saying we can have them without the ERA, or at the time she was just obviously using that as arguments against it when it didn't mean that. Clarifying why you said she used straw man technique, I suppose.
Yeah, it's because you're using a situation like that could arise. I mean, it doesn't have to arise because of that, and doesn't mean that it won't arise without that anyway. But you're using that as yeah, like a fear mongering, almost like saying, okay, well, that means like we're just gonna have everybody's just gonna abort all the babies like all the time. So let's not make abortion. It's kind of it's possible. It doesn't mean that it needs to. Yeah, it's almost just using one extreme example that might or might not be correct to stop everything else. You know, a bit like we see it all the time in terms of the other things about like immigration, like all these people are gonna come in and take all our jobs. I suppose it's possible, but it doesn't actually really work like that. And when you look at a lot of people come in, actually take like highly skilled jobs and things like that, and so on and so forth. It's the same thing that happened with that's been happening, you know, with Brexit, with the Trump campaign. So yeah, so that's why I said there was kind of the straw man techniques to
And that
do.
point, that last point, that the ERA will not give women any more rights than they currently have. How do you see that one?
So this is what we're talking about earlier in terms of the 14th Amendment. So the claim for this is that women already have these rights under the 14th Amendment. But what I'm saying is, I think that's an incorrect assumption, because that's like saying Black people have equal rights under the original Bill of Rights, which talked about all men created equal. And that's really down to interpretation. So it is right that there are some maybe some cases where the 14th Amendment has been used to uphold women's rights, but that doesn't mean it explicitly does so. It goes back to what Elder Pamindo was saying about how are you interpreting the Constitution. Someone might interpret that and say all men created equal means, you know, all men, women, different races, whatever. And someone else might be like, actually using originalism, it was just white men, so we should only protect the white men. So you need to be explicit to have true protection, and that's why you had all these other, you know, these other amendments. You could look at these amendments and think like, oh, these just appear in the original framing of the Constitution or the Bill of Rights. But then the problem was the interpretation of it. So you're kind of taking away interpretation, if that makes sense, because it's you can say that the 14th Amendment does talk about all citizens, but even as the Paminda read, in there, it's got a lot of male, you know, it talks about males in there. So yeah, so it's a technicality that I don't think is correct.
And it may be ironic now, but perhaps that I guess it links into the, is it fit for purpose now, that we've come a long way since the 70s for women's rights in some ways, so that whether this ERA would actually make much practical difference, I don't know. I don't know if you've got any thoughts on that, and whether it is like you keep mentioning, you know, gender issues and LGBTQ, and I suppose I don't know personally what practical difference it would make if this is passed at this point and in the way it stands currently. But that's another question, perhaps. The question, I don't know. Anyway.
Okay, so I asked the question to get us about this phrase which said the accepted time limit for ratification of constitutional amendment is 7 years. So I think, Curtis, from what I understand, you're saying is that they're saying that, or it's an accepted is kind of like, oh, that's just how we tend to do things, but it doesn't mean that that's actually the constitutionally specified way of doing it. But it's, you know, kind of like as a society, as lawmakers, this is just generally what we do. Like we see each other, we shake hands. It doesn't mean that it's in the Constitution that you have to shake hands with, you know, when you meet somebody, but it's just the accepted way of greeting.
Yeah, because there were other amendments that were passed years late, like 200 years later.
Right.
Yeah.
Well, do you know what amendment that was?
If you give me 2 seconds, I can find what it is.
Okay. So our case is finding that. Yeah, so I hope. Sorry?
The 27th Amendment.
27th Amendment.
Which prohibits changes in congressional pay from taking effect until after the election. So that was proposed in 1789, but was only reached ratification in 1992.
Okay, so there is a precedence
Yeah.
for things taking longer than 7 years.
Yeah.
Ratification. Okay, that's very interesting. Yeah, thanks for sharing that, Curtis. Okay, so yeah, I hope that helped us understand a bit more about the ERA and this constitutional ratification and some of the arguments that can be made for and against. So does anyone have any last question or comments? Okay, I suppose we'll stop there. Yeah, let's pray to close. Dear Lord in heaven, we thank you so much for your goodness and your mercy. Thank you for this time which we've come together to understand the things that are going on in our time, in history and laws, particularly to do with United States, which is the land that we should be watching, where prophetic history is taking place. We ask and pray that you may help us understand how these things going on in the United States impact us as individuals. Lord, how we as individuals also think about things, how we process things compared to what's going on, how we align with different arguments, and where we ask and pray you may show us where we're misaligned. Lord, we ask and pray a continual blessing on this day. Help us continue to keep your Sabbath holy. Please grant us your holy angels. Bless and strengthen us. We pray for the rest of the program, for all the testimonies and prayer requests. And please be with each and every member here. Please continue to alleviate our burdens and take our minds off the pressures of the week, the cares of life, and help us enjoy and really rest this day. We thank you and praise your holy name. In Jesus' name I pray. Amen.
Amen. And thank you, Tom. That was very interesting, interactive and inquiring session.